The doctrine of frustration provides one of the ways by which contractual obligations end. Where a contract is discharged by frustration, this occurs automatically by operation of law. The courts decide when a contract has been frustrated, and if they decide that it has, then all future obligations cease. The consequences of this are dealt with by both common law rules and statute, the Law Reform Frustrated Contracts Act of 1943. Key cases explaining the requirements for frustration are Taylor v. Caldwell from 1863 and Davis Contractors v. Farnham Urban District Council from 1956. In situations where there is a change in circumstances, not attributable to the fault of either party, such that performance of the contract would become something radically different from what the parties originally intended, justice requires that the courts should treat the contract as having come to an end. See National Carriers Limited v. Panalpina in 1981. It is quite possible for the parties themselves to make provision in the contract for what is to happen should the performance of the agreement become impossible or radically different as a result of some subsequent event for which neither of them is to blame. This is common in commercial contracts, which frequently use what are known as force majeure clauses. Where there is a clause of this type which covers the situation which has occurred, then the courts will give effect to it. Courts have consistently indicated that the contract will be frustrated only where there is a complete change between what was undertaken in the contract and the circumstances in which it is called upon to be performed. CCTI Group versus Transclear from 2008. The following types of frustrating events have been noted in the case law. Distraction of subject matter. The most obvious example is where the main subject matter of the contract has been destroyed, as in Taylor v. Caldwell from 1863. Personal incapacity. Another clear case of frustration will be where both parties have agreed that the contract is to be carried out by a particular individual and that individual dies or is too ill to perform. See Condor v. Baron Knights from 1966. Non-occurrence of an event. A number of cases concerned with the cancelled coronation of King Edward VII in 1903 illustrate this category. See Krell v. Henry from 1903 and Herne Bay Steamboat v. Hatton from 1904. Effects of war. In time of war, a government may make trading with companies based in enemy territory illegal. Contracts with such companies which were made prior to this action will be frustrated. See the case of Fibrosa Spolka from 1943. The frustration need not result from direct government action. See Finalvet vs. Vinava from 1983. Other government action. Government action not related to war can frustrate a contract. See Gamerco vs. Fair Warning Agency from 1995. Other frustrating events. Other types of event which have led to contracts being frustrated include industrial action, as in the NEMA from 1981, and the accidental running aground of a ship. See Jackson vs. Union Marine Insurance from 1874. There are two principal limitations on the doctrine of frustration. The first is where the frustrating event has been foreseen and provided for in the contract. The second is where the alleged frustrating event has been self-induced by one of the parties. In the commercial area, force majeure and similar clauses may well replace the common law and statutory rules on frustration. The courts have tended to interpret such clauses narrowly. See Jackson v. Union Marine Insurance from 1874. Another important element in the doctrine of frustration is that the alleged frustrating event must not be attributable to the fault of either party. If it is, then the likelihood is that the party at fault will be in breach of contract and the doctrine of frustration will have no application. The courts have interpreted the concept of fault widely in this context. In fact, it may be more accurate to say that wherever the alleged frustrating event is attributable to the actions of one of the parties, whether this involves fault or not, then the doctrine of frustration will not apply. See Maritime National Fish vs. Ocean Trawlers from 1935. One common law rule which operates even when the act is also applicable is that the frustrating event terminates the contract automatically, without any need for action by either party. It follows that any attempt to affirm the contract following frustration will be ineffective. See Hirji Mulji versus Cheong from 1926. As to the distribution of losses following frustration, the common law started from the position that all future obligations were discharged, but that obligations incurred prior to the frustrating event survived. Where the loss fell, therefore, would depend entirely on what the contract said about when payment was to be made or when work was to be done. See Chandler v. Webster from 1904 and Fibroza-Spolka from 1943. The inflexibility of the common law rules, even following the slight modification provided by the Fibroza case, led to demand for reform. This occurred in the shape of the Law Reform Frustrated Contracts Act of 1943. The two main provisions of the 1943 Act are Section 1.2, which deals with money paid or payable prior to the frustrating event, and Section 1.3, which deals with benefits conferred prior to that event. Section 1.2 provides that where money was paid or payable prior to the frustrating event, it should be returned if paid, or should cease to be payable if not paid but owing. Unlike the common law, this is not dependent on there being a total failure of consideration. The section provides that if expenses have been incurred towards the performance of the contract, some of the money paid or payable may be retained or recovered to the extent that the court considers it just in all the circumstances. Section 1.3 deals with the situation where a party has received the benefit other than money prior to the point at which the contract was frustrated. In that situation, the section allows that the party can recover from the other party such sum as the court considers just, having regard to all the circumstances of the case.